Hey everybody, welcome back to another week of Law, Politics, and Society. This week we're getting into the act of making law. So we're going to be looking at the Constitution, legal statutes, legislation, and judicial decisions. We're also going to start talking comparatively about some countries, including Canada, because I have a bit of a bone to pick with the authors of your textbook about the crime control due process spectrum question that I asked you earlier last week. So we're going to get into that and other common law countries and legal processes a little bit this week while continuing our focus on the US legal system. So I hope you enjoy the material this week. We're moving away from theory and into practice. One of the other things I wanted to emphasize was that I am obviously not going to go through every part of your textbook. Now, that doesn't mean that your textbook is not important. It absolutely is. But there's no point in me reading it aloud to you, right? These lectures are to supplement the textbook material, not to replace it. So you do need to still make sure you're reading the textbook. Okay, all that said, we want to start with common law. Now, what is common law? Well, this is the legal system that was brought to England during the Norman conquest and subsequent occupation of 1066. And this is the system that starts the legal system in America as we know it. The feudal system, which is what it was originally called, gets brought to England and becomes the basis for the common legal system. The common legal system develops through Henry II, the king from 1154 to 1189, and we develop this system of judgments that we begin to understand and apply commonly or frequently throughout all of England. And this develops over a period of time where you have judges making important decisions and you have other judges reading those decisions and becoming aware of those decisions. And this is what becomes the basis for common application or uniform application. And so this is what we call the common legal system. By far, one of the most important legal texts in history is the Magna Carta. The Magna Carta is written in 1215, and it is one of the earliest enumerators of some of the most important rights that we have as citizens today and that we have kept and that were very influentially kept in the US Bill of Rights. So the Magna Carta was a document drawn up by the barons of England to limit the power of the king and to make sure that particularly King John of Robin Hood fame gets subject to the law. So no more monarchs having all of this power and getting to be above the law and everybody else having to be subservient to the law. We need equality. And so this is what brings in the right to a trial by jury or a trial of one's peers, proportional punishment. We're not going to draw and quarter everybody. We're not going to tar and feather everybody. We're going to have proportional punishment. And we're going to put limits on the ability to require self-incrimination. You're going to have the power to say no, to refuse to speak. And prior to this, that was uncommon. Torture was very frequent. People would be compelled to speak in their own defense, and refusal to speak could be used against you. And so this is really what we moved away from with the development of the Magna Carta. And one of the things that became the basis for the common legal system is what's called precedent. So precedent is every legal decision by a court. And each time there's a legal decision, that's going to build on a previous legal decision. And these are going to continue to build on each other until you have this set of legal decisions that you can rely on and draw upon when you get a complicated legal question. So for American citizens, for example, one of the cases that created a very strong precedent whether we agree with it or disagree with it, is Roe versus Wade, the very often cited abortion decision by the US Supreme Court. So that decision governs all other courts. It binds all future decisions, as well as lower courts, to make sure they adhere to the precedent that was set in that decision. So it's important that we understand the role of precedent. And we often call precedent judge-made law because it's laws that are followed by the courts and that are enacted and treated the same way as any other type of law. And so this is the system that gets brought to America from England. And within the United States, precedent is only binding on courts within the jurisdiction. So the Supreme Court binds every other court, always. But if there's a Ninth Circuit appellate court judgment, that's only going to bind other courts within the Ninth Circuit. It's not going to bind any other court in any other jurisdiction. The same way that the US Supreme Court doesn't bind the Canadian courts or the French courts. So it only binds down, so it's a hierarchical system. Supreme Court binds appellate courts bind trial courts, but only within their own jurisdiction. So the principle behind establishing precedent is the Latin phrase stare decisis. And this means let the decision stand in English. And so we understand stare decisis to mean that if there's a prior decision on a legal issue that is relevant and applicable to a current case, we should use the prior case to inform our decision making. We should be guided by that decision. And the principle behind this is the one of predictability. We need certainty, we need consistency across cases, and to apply the law in a mechanism that's as uniform as possible. And stare decisis lets us do this, as does the phenomenon of precedent. Now, not every pronouncement a court makes in a ruling establishes precedent. The ruling itself, the decision itself, does, but there are oftentimes things that judges will say within a decision that are not. This is what we call obiter dicta. Obiter dicta are things that the court says that are more opinion, they're more conversational. They're not the reasons for the decision, they're not the meat and potatoes, they're kind of the fluff or the icing on the cake. They're not the really important bits, they just give it an extra bit of flavor. So obiter does not make precedent. The ratio decidendi, or the rationale, the reason for the decision, is the precedent-making part. Okay? Justice Scalia on the Supreme Court would very famously give a lot of obiter in his decisions. He liked to be a very fluffy writer. He liked to have a lot of fun words in his decisions or his dissents, but not all of those were binding. His dissents would be informative. They would give his opinion on the law. And even his decision makings would be precedent making. But a lot of the words or phrases he would use would not be. Those are just fluff. Another important thing to know about precedent is that it's not necessarily unchangeable. And we saw a legacy of this with the segregation cases, and then the Supreme Court's change to its approach in those segregation cases with the decision in Brown v. Board of Education. So prior to the decision in Brown, which required schools to begin to integrate, the U.S. had upheld what was called the separate but equal doctrine, which essentially allowed for segregation to be perpetuated throughout the South. And so when there's a change in legislation, it can often force the court's hand. And that's what we see during some of the civil rights era. Judge-made law or precedent can be overturned by the legislature. A precedent issuing court, like the Supreme Court, may overrule a previous decision. Times might have changed. They maybe need to move on from their opinions previously. Or there might be enough of a distinction from one case to another that requires different legal interpretation and different precedent to be applied. So even cases that look very similar, they may both be robberies, they might have stolen the same amount of money. If the facts about the defendant are different, case history, previous criminal record, right to counsel, and availability of counsel are different in those cases, there may be a very different precedent and set of cases that need to be applied to those decisions. So where do we get most of our laws from, and how do we make laws? Well, the biggest source of law and the most guiding central document in U.S. legal history is the U.S. Constitution. So the first attempt at making the Constitution was through the Articles of Confederation in 1781, but that document was exceptionally limited as it essentially left the federal government powerless. It had no ability to raise an army, it had no ability to tax or to make any revenue, and it had no mechanism to enforce compliance on the part of the states. So it was a really toothless document, and due to this, 12 of the 13 states met in Philadelphia to replace the Articles of Confederation at this Constitutional Convention in 1787. And the result was the formation of the U.S. Constitution. This created a very strong central government, a strong federal government that had the power to tax, had the power to raise an army, and had some powers to compel the states to comply. But the states were very concerned with establishing a federal government and a central government, particularly because of what they had seen as the tyranny that had oppressed them prior to the War of Independence. So there was a focus on making sure that the states would have enough autonomy and the states would have power to ensure that they could limit the federal government. So there was a balance that needed to be struck at the Constitutional Convention. And this is where we get a fairly, strong central government, but also almost equally strong states' rights. So the U.S. Constitution itself delineated this central federal government, but it actually had very few individual rights. It had the central provision for habeas corpus, which is important and we're going to talk about. It prohibited ex post facto laws, so it couldn't change the law after you'd already done something and said, oh, well, actually, we have a law against that. So it meant that it couldn't just create laws willy-nilly and punish people for behavior that they'd done before the law was created, which was important, but that was pretty much it. There were no individual specific rights to citizens. And this is a problem for the states. A lot of states demanded more individual protections, individual rights. And the result was the Bill of Rights, which was ratified by the states in 1791. And so the first 8 amendments out of 23, the first 8 amendments set out 23 individual rights. And they largely protect against state action. So they put limits on what the government can do to you as an individual citizen. But originally, these only applied to what the federal government could do to you as an individual citizen. It didn't protect you against what the state could do to you until the 20th century. It wasn't till the 14th Amendment, which was ratified much later, that we actually see this apply to the state governments. And so we're going to talk about that in a minute. So the First Amendment to the United States Constitution and the first part of the Bill of Rights reads, Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof. So we're going to stop there. That's the first half of the First Amendment. And so what does that say? Government shall not establish a religion. There will be no state religion. Also, government should not interfere with any individual's religious practice. So governments can't promote any religion, nor can they destroy religion. They cannot prevent you from practicing. They cannot delegitimize a religion. And so this first piece is typically referred to as the Establishment Clause. And so this is the area that puts a wall of separation between church and state. This is what the Supreme Court called the First Amendment, or the first half of the First Amendment, in the case that is really seminal to freedom of religion, which is Everson v. Board of Education. Doesn't mean that the government can't get involved in regulating religion, but the government may not excessively get involved in religion. One of the biggest cases that set out the limits to government involvement in religion was Lemon v. Kurtzman in 1971. Now, the Supreme Court held in Lemon v. Kurtzman that the government can be involved in religion if these three tests are met. The first is that the state has a secular purpose, a non-religious purpose, to interfere with religion in some way. Two, that the primary purpose of the statute that they're passing must neither be pro nor anti-religion. So it can't advocate or attempt to destroy religion. It must be neutral. And number three, that the state does not foster excessive government entanglement with religion. So there can be limited government involvement with religion. Valid government regulations are permitted, but it cannot interfere overtly or directly. So there can be, limited regulation, incidental restrictions, but not overt or hostile restrictions. One of the examples that often gets referred to is the ban on polygamy. So polygamy is the marriage of more than one person to another person. Marriage is between two consenting adults. If there are three consenting adults in a marriage, that would be bigamy, or a form of polygamy, which is the marriage of more than one individual. And some states, including the early Mormon Church, believed in the validity of polygamy. And they were very upset with the US government's attempts to control or restrict polygamy, as they believed that it interfered with their religious practice. But the Supreme Court held that the regulation of polygamy was actually under its authority because the primary purpose of the statute was not religious. It was actually to protect the welfare of the citizens through health and safety. And so if the state can prove that there's another purpose, right? We're not banning polygamy because we don't like Mormons. We're saying that we need to make sure that we ensure the health of the population. That might be a valid restriction, and it has been in this case. The second part of the First Amendment states that Congress should pass no law abridging the freedom of speech. So this is one of the most unique and most treasured rights in the United States, the ability to say things that will make other people mad, the ability to write things that might make other people mad. These can include things like signs, picketing, the burning of the American flag, or expressing what some might call hate speech. In most other countries, there are laws against what is called hate speech, or the willful promotion of hatred towards others. But in the United States, there's not, because of this central governmental protection of speech. However, the freedom of speech is not absolute. The Supreme Court has said that the government can regulate obscenity, So it can put limits on what it views as obscene content. This is why certain words won't appear on your TV unless it's satellite, because the FCC can regulate which words can be shown. It will regulate images such as nudity, which is why there'll be classifications on films as to what ranking is as appropriate for what age. And there are also limits as to what are called fighting words. So you cannot incite violence. You cannot do something to directly cause or deliberately cause other people to start rioting, for example, to deliberately injure or maim somebody else. But otherwise, it's fairly broad. And the courts have given a lot of latitude here. They've said that even individuals of the KKK, for example, when engaging in behavior like setting fire to a cross on a Black family's lawn, did not violate the First Amendment protections. They said it might be obscene, it might be cruel, but it's protected speech under the First Amendment. Famously, there was another case using the Westboro Baptist Church where a leader by the name of Fred Phelps protested and picketed a soldier's funeral with signs that said very hurtful and heinous things about gay people. Now, their son had passed away. This is at a funeral. And so to have those signs, they found incredibly offensive. But again, the courts found that it was protected under free speech. So there are some limits to free speech, obscenity, and fighting words most specifically, but very few, particularly compared to other countries. The Second Amendment is often subject to a lot of debate, particularly surrounding mass shootings. Every time that there's a mass shooting, the Second Amendment tends to come up. And the Second Amendment states, a well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. Now, this is largely a product of the Revolutionary War. The United States had fought a war of independence from Great Britain, and at the time, there were no public stores of weapons. So if the federal government was to decide that private ownership of guns was illegal, there would be no mechanism for states to fight back. There would be no way to just go and buy a gun. And so this was intended to protect private citizens and groups of citizens, or militias, to ensure there was no oppression by the federal government. This would allow them to protect themselves, the owning of guns. It's very much a product of its time, right? It didn't foresee things like automatic weapons, and it didn't foresee the federal government being so much more well-armed than average citizens. But it has been interpreted in a fairly progressive way to make sure that the most complete or encompassing understanding of this amendment has been possible. And so the way we see this expand is in a case called the District of Columbia v. Heller in 2008. And so this was a very famous case. Justice Scalia wrote the decision in a 5-4, very divided court decision that said that the Second Amendment protects individual gun owners directly, not just militias, but it protects individual gun owners, and that militias are merely one reason why an individual might need protection. Now, it does say that states and governments have the ability to regulate guns. They can put restrictions on guns, such as the age that you would be allowed to purchase them, the number of bullets you could buy at one time, for example. But it said that a law banning handguns in the District of Columbia was unconstitutional. You couldn't tell gun owners that they couldn't have a gun in a specific state. And so this has really become the central guiding principle of gun restrictions, and that we have to make sure that all restrictions we attempt in Congress follow the precedent set in District of Columbia v. Heller. And there was another case 2 years later called McDonald v. Chicago, which was similar, and it emphasized that while cities have a role in preventing crime and trying to deter specifically gun crime, they can't tell people that they can't own certain types of guns, and they can't ban guns outright. The United States is one of the only countries in the world, it's one of 3 countries that has the right to own weapons in their constitution. So again, this is an amendment that makes the US very unique, and it's a very rare protection. The Fourth Amendment, and this is an amendment we're going to talk about a lot later on in the semester, is the amendment that stands most directly between individual citizens and state agents, typically understood as the police. And the Fourth Amendment is the amendment that protects against search and seizure, illegal search and seizure by state agents. And the Fourth Amendment was written largely in response to the British practice of what are called general warrants, which essentially allowed the police to come in and search anywhere for anything at any time. And the framers wanted to make warrants available, but very narrowly tailored. So the goal here was to limit the ability of the police to interfere with the lives of private citizens. It required a reasonable amount of evidence that you would have to have before you could go and petition a judge for a warrant, and you would have to specify the thing that you were looking for, the place that you were looking for it in, and the time that you were going to search for it. So it's sort of like a game of Clue. You have to know, that it's Mr. Plum in the library with the knife. You basically have to be that certain before you go and get your warrant. So it doesn't say that all searches and seizures are illegal. It only bans unreasonable searches and seizures. So these are typically going to be searches and seizures without a warrant, although there are some exceptions to that, but we'll talk about that later in the semester. The Fifth Amendment does a lot of really cool things. It really sets out 4 specific criminal trial rights. The first is that you have the right to be indicted by a grand jury or a trial, basically a small minor trial before a trial. So a group of citizens hearing the evidence against you and deciding whether or not you should be formally indicted. It allows you freedom from double jeopardy, which we're going to talk about more significantly on the next slide, as well as the right to due process and just compensation, and the privilege against self-incrimination. Now, the right to due process and just compensation is sort of more relevant when we get to the 14th Amendment, so I'll talk about it more then. But the privilege against self-incrimination is really fantastic. It comes originally from the Magna Carta and says that you do not have to comply with police. You do not have to talk to the police. You do not have to talk to a judge or to a lawyer or to any state agent. You can remain silent and you can invoke that right. So often in TV shows or in movies, you will hear defendants saying, "I plead the Fifth," or "I would like to invoke my Fifth Amendment right against self-incrimination." That's what they're saying. I don't want to talk, but in the same token, the privilege against self-incrimination means that not only do you not have to talk, that the government or juries of your peers can't draw any conclusions from your decision not to talk. So they can't think to themselves, "Oh, he decided he doesn't want to talk. That means he's guilty." There are no inferences allowed to be made for the invoking of that privilege. So that's a really cool thing. Most of the rights that are associated with the Fifth Amendment were largely born out of reaction to things that had been happening in Europe during the Middle Ages. So we had the Spanish Inquisition, we had the Star Chamber, and we had Salem witch trials, which led to forced confessions, torture, mass arrests, and huge secrecy in the processes surrounding the criminal law. And so this amendment was really born out of a desire to eliminate that. And we've seen that be successful in the US court system. So the protection against double jeopardy means that any jurisdiction cannot try a person again for the same crime after a person has been convicted or acquitted, and they cannot punish somebody twice for the same offense. So let's say Jimmy is accused of committing an armed robbery, and we go to trial and Jimmy is found not guilty. The government can't tomorrow go back to Jimmy's house and arrest him and say, you know, we didn't get the outcome we wanted in the first trial, we're going to do it again. That's not allowed. If there's been a verdict entered, guilty or not guilty, that is over. You can't try it again. And even if Jimmy is punished and found guilty the first time, let's say we give him 15 years for his armed robbery, we can't then later say, actually, you know, thinking back on it, we don't like armed robbery at all. We think it warrants a 50-year sentence, so we're going to give Jimmy 50 years. You can't do that. You can't punish somebody twice for the same offense. But it does mean you can do some things that people frequently get confused about. So if you have a trial and for whatever reason the jury can't come to a decision, they're not able to decide whether somebody, our friend Jimmy, is guilty or innocent, and there's a hung jury, which means there's no decision, the state can bring it back to trial. They can try again. If they don't get a verdict one way or the other, they can bring it back. The same way that if there's a mistrial for whatever reason, let's say the defense accidentally introduces the wrong evidence, or a bunch of the jury members get the flu and they have to all be excused and we have to start over. As long as there's not been a verdict, the state can go ahead and try again. The state also can retry someone if the conviction is overturned on appeal. So if there's been an overturned decision, it essentially invalidates the first decision. It says that never happened. And so if it never happened, we can go ahead and do it again. It also doesn't mean that the person can't be tried under the doctrine of dual sovereignty. So this is sometimes confusing to students. So if, for example, you commit a murder in Texas, and Texas finds you not guilty, and during that murder that you committed, you actually kidnapped somebody from Arkansas and drove them to Texas to murder them. That means that you've used interstate commerce in the commission of a crime. And interstate commerce is the federal government's jurisdiction. And so even though Texas found you not guilty of murder, the federal government could try you for murder because you crossed state lines in the commission of that murder. So the states have one set of sovereignty rules. The federal government has another set of sovereignty rules. So Texas can't try you again, but the federal government can. And to make things more complicated, Arkansas could also try you for kidnapping because the kidnapping happened in their state, even though the murder happened in Texas. So if you're a criminal, be very careful not to bring people across state lines or do things in more than one state, because it means that the government will have more opportunities to try and convict you. So like the Fifth Amendment, the Sixth Amendment is also associated with rights relating to criminal trials, and again originates in that traditional Anglo-Saxon mistrust of government, particularly state secrecy, and this idea that things were being done behind closed doors without any transparency. And so some of the most important rights contained within the Sixth Amendment are the right to a speedy trial. So this has been held to mean by the Supreme Court without unnecessary delays. So There's what's been called the Speedy Trial Act of 1974 that essentially says we have to go from arrest to trial in 100 days. That's an onus on the part of the government to make sure it moves that quickly. But typically what you'll have is motions from the defense asking for things like evidence and witness lists and discovery, which we'll talk about later in the semester. And so it very rarely happens within 100 days, but it means that it can't be the government that's just delaying and delaying and delaying. So you have a right to a speedy trial. You have a right to a public trial. All trials in the United States are open to the public unless there's a national security concern as to why it cannot be. But the onus is always going to be on the defense to prove that it can't be public. So most trials are open to the public. The right to notice of charges against oneself. The prosecution always has to tell defendants prior to trial what they're accused of so they can adequately prepare. You can't just show up to trial and have the prosecution say, actually, I know we said we were charging you with armed robbery, but this is a murder case now. You can't have that. That doesn't happen. You have to have an official filing, and the individuals have to know what they're being charged with. And you also have the right to confront any witnesses against you. So the government has the responsibility to bring witnesses to trial, to give their information, and you have the right to cross-examine those witnesses. You have the right to make sure that you can ask them or have your attorney ask them anything that might be relevant to your innocence. One of the other parts of the Sixth Amendment that is important is the right to trial by an impartial jury. So not only do you have a right to a jury trial, if you wish, you can always opt for a judge trial in its place, but you have the right to a jury trial if you want one. And the jury must be selected from the community where the crime took place, unless it is impossible to get an unbiased jury in that town. So there are cases where you need a change of venue, but it will always be up to the defense to put in a motion for a change of venue if they don't think that they can get a fair trial in the town that they are in. And you cannot have jurors who have already formed an opinion about your guilt or your innocence. They have to be open to the evidence. They have to agree that they will only use the evidence that's provided in court to determine guilt or innocence. They can't have already made up their mind. And so this is where we get the presumption of innocence from, the idea that you have the right to be presumed innocent until the state proves otherwise. This is an ancient right. It was later affirmed in the Magna Carta in 1215 and has been something that has been carried through. So the presumption of innocence is one of the most standard but most important rights contained within the Bill of Rights. Another important thing that the Sixth Amendment gives us is assistance of counsel. So this means that you can ask for a lawyer at any critical stage. So what is a critical stage? Well, you can ask for a lawyer before your preliminary hearing. You can ask for one before you're arraigned and at your arraignment. So during the bail process, you can have a lawyer. You will have a lawyer if you wish one throughout trial. You will have a lawyer if you wish one throughout your entire appeal process. And because of the Miranda decision, Miranda v. Arizona in the 1960s, you may also invoke your right to an attorney during police questioning. And we'll talk about that more later on in the semester. But for the purposes of right now, what you need to know is that you have a right to an attorney at all critical stages. If you cannot afford an attorney, you must be provided one at the state's expense. Only if you're facing a level of jeopardy, including incarceration of 6 months or more. So if you're looking at a traffic ticket where you might have to pay $200, you can't say, I am entitled to a government-appointed lawyer, because you are not. You can only get an attorney provided to you if you cannot afford one, if your level of jeopardy is more than incarceration for 6 months. And one of the big distinctions here is it includes the right to effective counsel. So you don't just get a real estate lawyer who's never done a criminal trial in their life to show up and, ask a couple questions and sit down. You have the right to an effective lawyer. And if you can prove that your lawyer was ineffective during an appeal process, it will get you a retrial. So it is critical that you have a lawyer who is competent. So the Eighth Amendment also applies to criminal law. It says excessive bail shall not be required, nor excessive fines imposed, nor cruel and unusual punishments inflicted. So what does this mean? Well, it prohibits torture. This has been true since the founding of the United States. Torture is unconstitutional. It also prohibits punishment disproportionate to the offense. So if you speed, we can't put you in prison for life, right? Speeding and life in prison are not proportional. You need proportional punishment. But very controversially, it does not prohibit the death penalty. And you might be thinking, okay, but cruel and unusual punishment, if we're prohibiting cruel and unusual punishment, why aren't we prohibiting the death penalty? Well, the death penalty was seen to be in accordance with the standards of fundamental decency at the time of the passage of the Eighth Amendment in 1791. So this was seen as a routine punishment, and it has been challenged several times by several cases. We're going to talk more about these cases later in the semester. But generally, the death penalty has been upheld by the courts as being constitutional. It also states in the Eighth Amendment that you can't be given excessive bail, but it doesn't give you an explicit right to bail. And this was set out very clearly in the case of Stack v. Boyle in 1951. We cannot set bail higher than necessary to ensure the presence of a defendant at trial. So we can't say that we're going to impose a $2 million bail on a defendant that we would be pretty sure would show up if they were going to lose $25,000. So we need to be careful here. But if there is someone who is a very grave security risk or a very likely flight risk that would leave no matter what you put the penalty at, or that might reoffend, you can deny bail. You can remand the individual to a incarceration facility until trial. So there's no guarantee that you will get bail, but if the court is going to set a cash bail availability, they must do it in a mechanism that is proportionate. In my opinion, the Ninth Amendment is one of the most interesting amendments and is much more important than it ever gets any actual credit for. So the Ninth Amendment codifies the concept of natural law or natural rights in that there may be rights that exist out there, God-given or in the divine, that we have not accounted for here. And when I say we, I mean the framers and the founding fathers, right? There might be these other rights that we just haven't thought of and haven't put down. And so the Ninth Amendment states that the Bill of Rights is not an exhaustive list. It means that if the right in here, if there are rights in the Bill of Rights, this is not the only rights that a person might have. These are just the ones that we've enumerated. So it's not all inclusive. They say that there may be other rights here. You might have other rights that we just haven't written down. And so what other rights would you have other than the ones that have been written down? Well, you'll notice that one of the words that is absent in the Constitution and the Bill of Rights is the understanding of the concept of privacy, right? The Fourth Amendment says that you have a right to protection against illegal searches and seizures, but it doesn't say that you actually have any privacy. And so the Ninth Amendment has been used to afford privacy protections typically, as it did in the case of Griswold v. Connecticut, which is one of the earliest decisions regarding access to contraception and a woman's individual right to bodily autonomy. And Roe versus Wade, which was about abortion, and same thing, whether or not a woman's privacy and her bodily integrity could be compromised, or if a woman's right to choose her own path could be restricted. And the Supreme Court did put limits on abortion, but said that abortion generally could not be banned and should not be banned to give women rights and choices to make of their own volition. The most recent case that has used the Ninth Amendment that was relating to the concept of privacy was Lawrence v. Texas in 2003, which finally outlawed the sodomy laws that had existed since the 18th century. And so Texas was the only state that still had laws on the books against sodomy. And when taken to the Supreme Court essentially said it's none of the government's business what goes on between two consenting adults. And they struck down the sodomy laws. So very crucially, the Ninth Amendment has been interpreted as the right to privacy, particularly in your bodily integrity. So the 14th Amendment was part of a package of amendments that came in during the Reconstruction era, or shortly after the Civil War ended in the 1860s. And one of the things that the 14th Amendment does is it forbids the states from mistreating citizens. And it states that the states cannot deny citizens due process of law, which you'll remember from the Fifth Amendment, or equal protection. So what does that mean? Well, the Due Process Clause has been understood to mean that the Bill of Rights largely needed to be applicable to the states. So until the 14th Amendment, largely the Bill of Rights was only applicable to the federal government, which meant if the state of Wisconsin infringed on your rights, that there was really nothing that could be done. It was only if the federal government infringed on your rights, then there would be a case for redress. And so the 14th Amendment said, no. The states are just as powerful, and they have, just as great a responsibility. They need to protect citizens' rights as well. And so this was a process that occurred over a number of years, the incorporation of the Due Process Clause to the states and the Bill of Rights to the states. But the 14th Amendment also has what's called the Equal Protection Clause, and it bans the states from making arbitrary and unreasonable distinctions between citizens. So it's allowed to treat people differently if there are reasonable distinctions, like creating age limits for driver's license, or smoking, or voting. But it's not allowed to treat Black people differently than white people, for example. And this is one of the central tenets that came out of the jurisprudence of the 14th Amendment. So prior to the 14th Amendment, the Bill of Rights only applied to the federal government. And we know this because of the case of Barron v. Baltimore in 1833. This was a Supreme Court decision that said that the Bill of Rights did not apply to the states. And this started to change after the Civil War. We have the passage of the 14th Amendment in 1868, and the goal was to protect recently freed slaves from tyranny and abuse in the South. And so if the clause, the 14th Amendment, was only going to apply to the federal government, then it would never be able to be used to protect the slaves, because the oppressors would come by the hands of the state governments. So initially, we see the 14th Amendment being used as a mechanism to incorporate the Bill of Rights only to freed slaves. So it starts off very narrowly, and it says, okay, we will protect the people that are in the most gravest of danger, from the most likely aggressors, and that was free slaves in the South. So this was the beginning of incorporation. And then the most societally accepted mechanism for total incorporation came through what is called selective incorporation. This was the most prominent opinion of the Supreme Court at the time. There were some that argued for total incorporation right away, but this was not popular. And what we got was this piecemeal approach. It was gradual and it was selective, and it happened on a case-by-case basis, where you would have individual rights applying to the states, checking to see whether or not these rights should be incorporated, and then gradually the Supreme Court would say, yes, actually, we think the First Amendment applies to the states. The states have to protect free speech. Yes, we think the Fifth Amendment applies to the states. We don't want people to be able to incriminate themselves. So it led to the incorporation of just about every right in the Bill of Rights. The Second Amendment just came in Chicago v. McDonald in 2010. And the only right that has not been incorporated into the through the 14th Amendment of the original Bill of Rights is the Seventh Amendment. That's the right to grand jury indictments. And it's largely because it would be way too expensive and take far too much time. So it's unlikely that the Seventh Amendment will ever be fully incorporated. Okay, so we know there's a Constitution. We know that we have a bunch of rights. But what happens if the government violates those rights? Who checks? Well, this is a really neat phenomenon, and it's called judicial review. And so judicial review is the power of a court to examine legislation, either passed by Congress or passed by the executive as an executive action, so the president, and determine whether or not it's constitutional. So this is really cool. So you have this mechanism for judges to look at laws and say, yep, that law is constitutional, or nope, that law is not constitutional, it needs to be struck down. But this power isn't given to judges anywhere in the Constitution. It's not given to them in any legal statute. It actually is so fascinating because judges gave it to themselves. It's a judge-made law. It's the result of a decision called Marbury v. Madison in 1803. You can tell how excited I am about this. I love this case. And so what happens in Marbury v. Madison is you have President Adams, who's been appointed to serve as president, and he's turning over the office to the new president, Thomas Jefferson. And so the Secretary of State goes and delivers all of the commissions to the newly appointed justices, but either fails to deliver Marbury's commission or deliberately doesn't hand it over. So James Madison, new Secretary of State, says, nope, I'm not giving it to him. And so they apply to the Supreme Court and says, hey, there's a writ of mandamus here. We want you to compel him to give him his commission so he can go work as a judge. And the Supreme Court says, okay, yeah, we will hear it. And then Congress passed a law saying, nope, you can't hear cases regarding our decisions. Nobody's going to check our decisions. But the Supreme Court in 1803 says, no. Actually, yes, we can check your decisions, and we're going to listen to the case. And so they decided that, yes, Marbury should get his commission, but that it didn't have the power to issue a writ of mandamus, because only Congress could issue those. So it compelled Congress, it said, Congress, you must write the writ for this individual to receive his commission. Marbury is entitled to his commission, thus you must fix it. And so for the first time, you have a Supreme Court telling Congress what to do. And this became precedent. The Supreme Court has continued to tell Congress what to do for the last 200 years. And because they've done it for so long, this has been the law of the land. And very interestingly enough, they didn't use the power at all. between 1803 and 1857. So for 50 years, they didn't check any legislation to see whether or not it was compatible. But this is now the societally accepted method to check whether or not a law is constitutional. So if Congress passes a law tomorrow that says, nobody is allowed to go out and protest, the Supreme Court very quickly would get that law, would get a case saying, hey, this is what the court has done, and say, no, that is absolutely not allowed. That's in violation of the First Amendment. And so now Congress has a pretty good idea of what laws the court will accept and what laws it will reject. But of course, this changes every time the makeup of the court changes, because each of the individual justices will have a big difference of opinion. And this is why it was so interesting when Justice Scalia passed away, and there was a vacancy on the Supreme Court, and who was going to get to fill it? Was Obama going to get to fill it? Was the new president going to get to fill it? What was going to happen? And we know that Obama didn't get to fill that vacancy. That vacancy was held up until President Trump was elected, and he subsequently appointed Neil Gorsuch to the court. And then we had the retirement of Justice Kennedy, and then the subsequent controversial appointment of Justice Kavanaugh. So you could really see how incredibly important the Supreme Court is because of this very important function, where they get to check the constitutionality of all pieces of legislation. One of the things that became clear after the passage of the Reconstruction Amendments was that not all amendments were created equal. Not all rights had the same level of privilege, and some rights were going to be more important than others. And this was determined in a major case called Palco v. Connecticut in 1937, which looked at the fundamental rights, or the rights that the Supreme Court called, quote, essential to the concept of ordered liberty. So those are very specific rights, and it means that some rights would have more protection than others. And these include the First Amendment, voting, the ability to move freely and independently, and privacy rights. So those would be more important than some of the other rights. As well, and incorporated through the 14th Amendment, it would depend on whether or not there were suspect classifications involved. Suspect classifications are when the law treats certain classes of people differently. So this ties into the Equal Protection Clause of the 14th Amendment and looks at whether or not the law has been unnecessarily based on race or gender or religion or national origin. But only race and religion have consistently been considered what are called suspect classifications. And I'll explain how this works in the next slide. So when deciding whether or not a law is in violation with the Constitution, we have to understand what standard of review we're going to be using. And the highest standard of review is what we call the strict scrutiny test. And under strict scrutiny, the state may not enact legislation that abridges any fundamental right, those voting, privacy rights, those travel rights, unless it has a compelling interest to do so, and it would have to justify that, it would have to demonstrate its compelling interest, and the law is narrowly tailored enough so that rights are not abridged more than necessary. So this looks at the purpose and the effect of the law merely than just accepting the legislative claims of what it's going to do. And so anytime you have a fundamental right and a suspect classification, you're going to use the strict scrutiny test. An example of this were President Trump's first two attempts at a travel ban, stating that individuals from certain countries, specifically Muslim majority countries, would not be able to enter the United States. And the Supreme Court struck down those attempts at restriction using the 14th Amendment and a strict scrutiny-based test, saying it's clear that you are making distinctions between people based on suspect classifications without any legitimate reason. The government could not prove that there was a compelling reason to ban just individuals from those countries. The next standard of review for legislation is called intermediate scrutiny. So this is a step down from strict scrutiny, but the burden is still on the government to prove that the law is necessary and that the law serves an important governmental purpose, like security. This standard is used when the law that is being passed invokes what are called quasi-suspect classifications. So these can be things like gender or sexual orientation or sometimes nationality. And when we have a law that involves a quasi-suspect classification, the government has to demonstrate that the law is needed and related to a significantly important enough governmental purpose. This test is not used nearly as frequently because it is very infrequent that there is a law that is based primarily on a quasi-suspect classification. The easiest and most common form of review is called the rational basis test. And so this is what the courts used when there's no fundamental right in question and there's no suspect classification in question. And it states that the government is allowed to pass laws that affect individuals' rights and that may affect a class of people, as long as there's a justifiable rationale behind doing so. So this is obviously a much easier test to pass. The legislature doesn't have to prove that it used the best possible means, merely that there is a relationship between their objective and the law that they passed. One of the big differences also of the rational basis test is that the onus is on the challenger to prove that the law is unconstitutional. So instead of the government having to defend the law, the onus is on the person challenging it to determine whether or not there was a rational basis. So the onus is now flipped for this standard of review. So what if the Supreme Court gets it wrong? What if there's a decision that we think is incorrect as a society? Well, the Constitution can be changed, and a Supreme Court decision interpreting the Constitution can be changed only by a constitutional amendment. So how do we do that? Well, in order to successfully pass a constitutional amendment, you need 2/3 of both houses of Congress, so that's the House and the Senate, passing a resolution calling for this constitutional amendment. And then it has to go and be ratified by 3/4 of all of the states within a 7-year time frame. So that's the first way you could do it. The second way you could do it is to have 2/3 of the states together calling for a convention when you would have a proposed amendment. That has never worked so far. We've never had 2/3 of the states call for a convention. All of the amendments that we have had passed have been through Congress than the states. So famously, there was a constitutional amendment, the 18th Amendment, which abolished the ability of citizens to buy and consume alcohol. So this is called prohibition. And it was also the only amendment that has ever existed that has been repealed. So for a period of time in the 20th century, there was prohibition, inability to buy or consume alcohol because of a new constitutional amendment, and that amendment was subsequently repealed. So this is getting into the meat and potatoes of how laws are created, why and how laws get changed, I hope you found this week really interesting. You can tell it's one of my favorite topics. We're going to get deeper into each of the individual amendments and how they affect law later on. I hope you had an awesome week. I'll talk to you soon. Bye.